This video is about the IRAC method, but unlike the hundreds and hundreds of other videos you can find on the internet about IRAC, I'm not going to be talking about the IRAC or any of its many permutations and combinations at all. Instead, I'm going to exclusively focus on the things that you should do before you start an IRAC problem. All of these preparation steps. All right, let's go. Fundamentally, there's only three things to know: who, what, and why. That is, who are the people, what's the stuff, and why do those people care about the stuff? Really, that's all we're asking ourselves before we start an IRAC problem. Now, that's perhaps a little bit glib, because there's a fundamental difference in doing an IRAC-style task as a practitioner as opposed to a law student. And while it may seem really obvious when I say this, it's definitely worth thinking about, because there is a preliminary step to these preliminary steps if you are doing this as part of your university or college undergraduate in work, and that is you need to work out what the instructions are, who the people are who are telling you to do things, and how they want it done. So I've kind of included that here as a little bit of an additional step. I've called it step 0. Later on, I'll talk about step 4. And again, it really doesn't form fully part of these preparatory steps, because step 4 functionally is doing the I part of IRAC itself. I'll go through each of these in turn. So this step 0, the bit you do before you do the bits before you do your IRAC task, is essentially just reading the instructions. Now, I know that it seems a little strange to be asking this, but fundamentally, in a hypothetical or an academic task, you have to ask yourself who you are and who your audience is. In practice, this is a given. You know who you work for, you know who your boss is, you know who you're producing a document for. In academic tasks, it's not always so straightforward. Sometimes it can be implicit, and sometimes it can be expressed in the instructions. So as such, you should determine what your role in the scenario is. You should determine who your audience is, and as a result, you should be able to work out what type of document you're going to produce. And this matters because the style of document is absolutely going to change depending on whether it's going to a client who won't be au fait with the law, as opposed to another lawyer, as opposed to a judge. You need to analyze these things, work it out, map it out before you start. The next thing that we look at, which I've called step 1 here, is the people. We need to work out who our client is, usually that's pretty straightforward, and who the other parties are. We need to remove, or at least identify, the parties that aren't going to be relevant for the purposes of a given scenario, both hypothetically and in practice. And you need to know functionally of those parties and people, who are the ones who are going to be able to bring a cause of action. Now, it may be that your client is the one who wants advice to bring an action against one or more other persons, or it may be other persons trying to bring an action against your client, and you'll be providing them with advice there. This first step, in some situations, can be quite trivial. In others, it can be quite complex, and in particular in practice, where there are intervening parties, insurers, for example, or others who have stepped into the shoes of persons that your client may have made arrangements with. It's worthwhile going through and mapping this stuff out ahead of starting your IRAC challenge. The second step in the preliminary steps that we're taking before we start our IRAC is to look at the stuff. Now, I've deliberately used a very broad expression because stuff can refer to physical things such as money or assets, but it also can refer to legal phenomenon where we need to either analyze that or it's a given part of the scenario. The main one for the purposes of the example I'm going to give later is the existence of an agreement, whether that be a contract or not. Commonly, scenarios in the civil system or sphere involve one side or the other having to compensate the other side. So usually one side is going to be wanting money, fundamentally. Often there's an asset and money. And sometimes it can be the dispute on quantum as well. Now, the stuff component when you're doing an IRAC-style situation in the criminal sphere can be to look at particular items of evidence. This can be physical things for the commissions of crime, but a common thread between these is the existence of documents. Are there documents, and do those documents need to be found in order to produce better advice for your client? The third step, again, is going to seem very obvious, and in many situations it is, but fundamentally, why do the people care about the things that you've identified in step 2? Often it will be that one side wants to be paid or doesn't want to have to pay. One of the parties might want to know if they're going to be liable for criminal sanctions. In each of these situations, when you've got a dispute where you've got your client and the other party or OP, if their interests are directly opposite to each other, often this is going to be one of the core things that you'll need to analyze as part of the IRAC problem. In the case of things like breach of contract or even determining whether a contract exists, often there will be an asset and there will be payment, which may have already occurred or it may be about to occur. In that situation, it's not uncommon for one side to want to be paid and the other side to not want to pay or return money that's already been paid. So even though these things seem really obvious when I say them, it's very important to map this out, to be clear about what the parties want, because once you've determined this, then you have to start using aspects of law to try and draft the first or high-level issue. I've phrased this as step 4 in the process, but really it's the first step that you're taking in doing your IRAC problem. You've worked out who the people are, you've worked out what the relevant stuff is, you've worked out why those people want that stuff or determined what they want in relation to those things. Now you have to draft the high-level issue. Now, often it'll be something along the lines of, can a person bring an action in a particular area of law? If you're doing an academic task, you will be confined to what the instructions or the particular topic limits you to. For example, if you were doing a topic on duty of care and negligence, you wouldn't be examining other things, for example, any potential contract or trust type relationships in regards to that. In practice, though, there can be many legal issues that arise from a particular set of circumstances. That's where your legal experience and your knowledge comes in to try and derive each of those potential causes of action, both for and possibly against your client. So now I'm going to really quickly go through a simple scenario involving a contract. Here, the initial step, the step 0, involves us looking at this particular situation and scenario, but paying close attention to our instructions. Here, we are a junior solicitor, and we have been asked by a senior solicitor to provide advice. So as a result, in producing this piece of work, assuming there's no other instructions that are given, you'd be expected to do that in memorandum or memo style. You'd be expected to use legal, technical words and jargon where appropriate. You'd be expected to show the appropriate citations properly referenced. And you can assume that the other lawyer knows all other areas of law. That's fundamentally examining your target audience and drafting the document accordingly. If this was a letter to client, some of those things wouldn't apply. While we might have things like footnotes, we probably wouldn't use in-text citations and Latin phrases and technical legal jargon. We would have to use language more appropriate for a layperson to read. Or if we were making an argument before the court, we would have a very particular structured document that would be formatted in a particular way, depending on whether they're set out in terms of pleadings or we were doing some sort of appeal point. In either situation, the initial analysis of our task is really important for setting the scene. So now we would do step 1 of the pre-IRAC step-by-step method, which is to look for the people. And here it's pretty straightforward. We know who our client is. We know who the other side or the OP is, which is Mr. Alfonso. Our client's Mr. Meehan. And there aren't any other people mentioned in this scenario. So this is quite a simple exercise. It's pretty straightforward. Step 2 is to look at the stuff. Here, the two assets, again, are very straightforward. And look, sometimes these things can be very obvious, but it's a really useful process to go through and map these things out every time. Do it religiously, and it'll really help for your future learning. Because in this situation, while $20,000 and a chair are the two assets, there is one third piece of stuff, which is an apparent contract. There isn't any other information about any form of documentation, but on the face of it, it looks like there was an oral agreement that seems to satisfy all of the elements of a legal contract. And so we would really want to identify that, because when we do our analysis, we're going to assume that there is an apparent contract in existence. Step 3 is to look at each of the parties in relation to the stuff, work out what they want. Here, again, it may seem straightforward. One person wants the money or their money back. The other person wants to keep the money that was given to them. Neither side wants the chair, or at least are ambivalent about the chair itself. In regards to the contract, the way that we would express this in step 3, moving into step 4, is to state this in slightly more technical legal language that our client wants the contract to be upheld, the apparent contract, whereas the other side, the OP, wants the contract to be undone in some way. Here in this particular scenario, we are doing this particular tutorial problem after learning about the rules for unilateral, common, and mutual mistake in contract law. And so that also narrows the scope of the particular topic that we would go and analyze in the step 4, or the first I in IRAC. So it's important to note that in actual legal practice, you wouldn't have that limitations of scope. You would go and be examining potentially lots of different areas that the other side could have thought about bringing an action under. Now, for the purposes of this scenario, the high-level issue is simply going to be, can Alfonso have the contract undone, either rescinded or rendered void? Because if he does, then the title to the chair doesn't pass, and the money that's been paid still belongs to Alfonso. There is no contract. So that is the starting point that you would begin your IRAC analysis on. And that's it. Fundamentally, these are simple steps that you can do before you do any given IRAC task. Each of them seems commonsensical, they seem trivial, they seem small, but if you follow this rigorously and religiously when you do these problems, when things get complex, you'll have the skills to go about breaking those things down. And hopefully, just hopefully, it'll help make you a better lawyer one day too.